City of San Francisco passed an ordinance. The ordinance required that all manufacturers of sugary drinks have a disclaimer, a warning on their advertisements. And the warning had to say basically that sugary drinks can cause obesity, diabetes, and tooth decay. And importantly, the city also required that that warning be big, that it take up 20% of the entire ad space on all ads that were placed on public billboards, transit signs, various other things that were within the city of San Francisco. Well, needless to say, the guys on the other side of this, the manufacturers of the sugary drinks, said, oh, we don't like this, we don't like this, and we find that it's a violation of the First Amendment of the U.S. Constitution, the freedom of speech. So they brought suit. They take it to federal court. And there, the federal court heard the various arguments. And the arguments that were made on behalf of the city said we have good research showing that sugary drinks do contribute to diabetes, obesity, and tooth decay. And moreover, we're requiring it be 20% of that full advertisement because we find that people pay more attention if the warning is basically 10% of the entire ad. Okay, on the other side, manufacturers say, fine, maybe the studies show 10%, but you're requiring 20%. That's too much. We're paying for this space, and 20% is too much, and we find that burdensome. Because it's burdensome, we find that it violates the First Amendment. Well, trial court said, you know what, I agree with the city. I agree with the city, and I think that you have to basically provide that notification, that warning, that's 20% of the advertising you buy. Well, the guys weren't happy, so they appealed it into the Ninth Circuit Court of Appeals. Up there, the Court of Appeals heard the same arguments, and they came to a different decision. Yes, they came to a decision that says, you know what, we think that this probably is burdensome because it's 20%. Now, we think 10%, we're not saying it, we're not saying 10% is too much or too little, but 20% we think is too much, and therefore, we think it needs to go back down to the trial court to take another look at this, and it was remanded to the trial court. And that's where it went for a decision as to whether or not it was constitutional or unconstitutional. Okay, so what do we learn from this case? While the Ninth Circuit didn't really make a firm decision, what it did indicate is that if a lot of space is required to be taken for a warning in an advertisement, that could be a violation of the First Amendment. Now you may say to yourself, how is that a violation of the First Amendment? I thought First Amendment was all about freedom of speech. You get to say what you want to say. So if you have to say something, how is that a violation of the First Amendment? Well, it's because the First Amendment provides for freedom of speech, and that freedom goes both ways. It means you can say what you want to say, but it also means government can't tell you what to say. There cannot be any mandated speech. The government cannot come along and say that all citizens must engage in a particular kind of conduct or speech, because that's violation basically of free expression. Now, we all know that cigarette packages have warnings on them. We all know there are other warnings. Those warnings have passed constitutional muster because they're found that they are not too burdensome, that the manufacturer, the advertiser, isn't paying a lot of money for space that is required to be used for a warning. We also find that there is a good rational basis for that warning. And in cigarettes and in sugary drinks, at least according to the city of San Francisco, there's a rational basis to say there's a correlation between the use of the product and a disease. And therefore, if that's demonstrated, it is a simple warning. Okay, so this is what we learn from this. What we learn from this is that freedom of speech is the freedom to say what you want to say, but it also means you can't be compelled. You can't be made to say something. All right. Bring you this case, we bring cases every week so you understand how the law works. I'm David Allen.